everybody, welcome to this week's LAB. I hope you're well and enjoyed this unseasonably warm weekend. This week I'm doing a video about negotiation because at this time of year, lawyers everywhere are frantically trying to negotiate before the end of the financial year. If you don't know this already, when you go into practice, you will soon come to realise that the end of the financial year might as well be the end of the world. Everything must be done before the end of the financial year or everyone's heads will explode. So I've been doing a lot of negotiating recently, so I thought I would do a video on it. First of all, I want to dispel the misconception that a successful negotiation is about one side winning and the other side losing. A successful negotiation is about both parties coming out happy and with something that they wanted and something that they feel that they can progress with. So to that end, the idea is to narrow the gap between the two of you. At the beginning of a negotiation, you will probably start like this, and the idea is by the end of it, you are somewhere more like this. So you're unlikely to end up with absolutely everything that you want, and the opposition is unlikely to end up with absolutely everything that they want. But the idea is that you both end up with some things that you want and you're happy with. So first of all, you need to determine your goals. What is the purpose of this negotiation and what are you hoping to achieve from it? Are you disagreeing with your opponent over a point of law or a point of procedure? Or are you entering into a settlement negotiation where you are very far apart on your ideas of what the value of the claim is? Or what is it that you are arguing about and what is it that you want to achieve at the end of it? You then need to do the same for your opponent. You need to understand what your opponent is wanting to achieve out of this situation, because the more you can understand that, the quicker you will come to a successful resolution for both of you. You then need to set some parameters. So you need to decide on some things that you can potentially concede on and some things that you absolutely cannot budge on. And then perhaps some things in the middle that you'd really rather not concede unless you absolutely have to. But if they gave you some things that you really wanted, maybe you could let a few of them go. You then need to discuss and explain your parameters really clearly to your client, because the last thing that you want is to come out thinking you've had a really successful negotiation, but then your client is really upset because they don't understand why it's been successful. Particularly if you're arguing over a point of procedure or a point of law, it may not be immediately apparent to your client what is a successful outcome. So it's important that you always explain this really clearly to your client and take their instructions as well to make sure you're always acting in the best interest of your client. Shock horror, the next one is prepare. Prepare? Who would prepare for anything? I don't think I've ever told you to prepare before. Fail to prepare, prepare to fail. I say it every time. But again, with negotiation, a really good tactic is to be completely ahead of your game. So for anything they could possibly query or say, you have got the counter argument right there on the tip of your tongue, because it makes you come across as a strong negotiator and that you really know your case inside out. And it makes people less willing to mess with you. And you often get what you want much quicker if you've got real strength in your response. And the only way to do that, unfortunately, is to know your case inside out through really thorough preparation. When you're in the negotiation, listen really carefully to your opponent and make mental notes. You will often find that as you go through the negotiation, it will become clearer and clearer exactly what they want and what they are willing to concede. And the more you can understand that, the quicker you will be able to determine what you can concede and what it is that's going to make you reach a successful resolution quicker. You may also find out that there are actually some things that they want that you didn't know that they wanted, and maybe you can concede those things actually, but then you've got to tactically decide when to concede those things to make sure that you get all of the things that you want as well. Although it's really important to have a structure before you set out, it's also a good idea to make sure you can go with the flow a little bit. Some things might come up that you don't expect, or you might have a really difficult opponent and you might end up having to concede some things at the beginning that you really didn't want to in order to move things along. But the art of a successful negotiation is to improvise and be able to react to things as and when they arise. And the key to that, again, is successful planning and preparation to make sure you can adapt to any situation that comes your way. Another thing to really bear in mind is what are the consequences if you don't negotiate successfully? If you just cannot resolve the issues, what happens? More often than not in a legal negotiation, you end up in a courtroom asking a judge to decide the issue. And that carries with it a lot of risks and potentially a lot of costs as well. So make sure when you are looking at the things which you absolutely cannot budge on that you bear in mind the reality and the risks of what happens if you don't concede those points and you end up in front of a courtroom. Hopefully at the end of it you do reach a successful conclusion, and when you do, it's really important to do the follow-up steps straight away. So whatever it is you need to do, if you need to write a letter to the opponent, if you need to file something at court, you need to pay some monies, do it promptly, act proactively, because it shows that you are taking charge of the situation and you're not messing around. And don't forget that these issues often don't occur in isolation. This may be one negotiation on one particular case, but the way you act in this negotiation will dictate how the opponent treats you throughout the rest of that case, and potentially in other cases, because you will often find you come up against the same opponents time and time again. So it's really important that you make a good impression and act well, because this will set the standard for the rest of your litigation career, potentially. Okay, that's it. I hope you found that helpful. As always, please leave me some feedback, ask any questions, leave me some comments below, and I will try and respond to them as quickly as I can. Hope you enjoy the rest of your week. I will attempt to get some videos up over the next couple of weeks, but I am on holiday, so please don't hate me if I don't get them up. I'll try my best, and if not, I will see you guys back in a couple of weeks. Bye!